Now we'll hear from Miss Evans.
Yes, this is wax nose time. I'm going to talk about the law on all this in England, and it will become clear as I go through why I'm saying England and not Britain, because the law as it affects application in Britain is now being narrowed down into the devolved administrations. I ought also perhaps to explain where I'm coming from, like Tom did. I live in the 12th century, really, which is where Oxford was getting its act together, a bit ahead of Cambridge, as you know. And that's important because it makes one conscious how very recent the concept, with a label attached to it, of academic freedom is. And that takes us back into some of the questions raised in the first two papers this morning, which is how far we're dealing with something of eternal value, or perhaps not to be quite so theological, long-standing value, and how far we are at the mercy of shifts in fashion of opinion, which will change, but we don't know which way yet. I'm also going to, I think we're having every possible mode of delivery this morning. We had 2 lots of PowerPoints. We had a stand-up lecturer. I'm going to do a sit-down seminar paper. But you will listen just... In fact, it gives you better eyeball-to-eyeball confrontation at this level, I think. Now, on the face of it, academic freedom in England is quite well protected. 2 bits of legislation with that purpose, dating from the 1980s, remain in force in English law. Both prompted strong words in Parliament, which is one reason why I'm reading, because I want to read you some quotations. And they're very easily accessed online in Hansard for those from the United States or other countries outside this one. And they read as topically now as they did 30 years ago, as you'll see. But meanwhile, the world of discourse has certainly changed. Eric mentioned the history of attitudes, which is very much this question of where we are now and why the young tend to think that's the only place to be. And some of the things Heather said related to the same point. Among the things that's changed in English law is the prevent duty, and I know those who are British will be well aware of this, which is to, quote, have due regard to the need to prevent people from being drawn into terrorism, unquote, imposed under the Counter-Terrorism and Security Act of 2015. Now that's making it much less easy for universities to be sure what is lawful free speech. The Equality Act in 2010 makes unlawful discrimination, harassment and victimisation of a person with any of a very wide range of protected characteristics. So human resources in most higher education providers in this country have put a great deal of energy into creating procedures to be followed when it's alleged that something's been said which could fall under one of those headings. Tom mentioned harassment. Social media have encouraged trolling and of and also by academics in language which is both ugly and sometimes unlawful, and which of those are we gunning for? Both the provisions of the 1980s came into being in reaction to headlines and resulting political concerns of the moment, and their durability is the more remarkable when so much has changed in the world of English higher education and in the rest of the law's requirements. This, again, I think is a general point that keeps arising. Reactive legislation, which is very much the thing in this country, but the response of universities to the threat of the moment without necessarily tying it back into the wider, lasting ground rules, which I think people in this room probably sympathise with. Now, the first protection, in a context where I was quite surprised that Eric had found what he did at Bristol, it was designed to prevent the no platforming, which was rife in the 1980s, just as now, so as to protect the right of invited speakers to have their say, provided it was lawful. In the physical ambit of an institution providing higher or further education. Now, that's important. It was territorial. Whoever you were, if you were in a university, making a speech, giving a paper, you were allowed to say it, whoever you were. You weren't an academic necessarily, and you weren't necessarily a student. You could be anybody. It was a topic that promoted some very energetic parliamentary debate. The lawyer Baroness Hooper used language in the House of Lords, which I think could be used equally well today, and I'm quoting here. The government are greatly concerned about the number of occasions in recent months when invited speakers have faced uncouth behaviour and worse on university campuses, and more subtle but no less insidious about the indications that some student bodies have sought to impose a ban on invitations to certain organisations or individuals. The government see freedom of speech as a fundamental right in a democratic society, and it is above all fundamental in an institution of advanced learning. All young people should be helped to develop minds that are open to opposing arguments and capable of discrimination and judgment. No one should be forced to listen to debate irrelevant to his interests, but no one should be denied the opportunity to deepen his understanding of issues that concern him. It's right that universities should hear speakers on all subjects of general interest, and members and societies of a university should be able to invite such speakers in the confidence that they will receive a hearing. You could make that speech today. Every higher education provider in England still has a duty to publish a code of practice to ensure compliance with the resulting statutory duty on an institution to protect freedom of speech. You can find it, if you want to see, in Section 43 of the Education No. 2 Act 1986, which was amended, and this is very interesting, only slightly in the recent Higher Education Research Act of 2017, just to redefine the institutions affected, because there are now many more English providers of higher education, including the private providers, which we're now learning to call alternative providers. This important principle has endured, which is that the speaker doesn't have to be an academic, and the freedom of speech protected is a general, not solely an academic freedom of speech, and it is, in a sense, territorial. It's campus-based. Makes it tricky in Oxford, where the whole city is full of bits of campus. The second protection was the result of concerns raised when it was proposed to abolish old-fashioned academic tenure. And Tom had something to say about tenure. The expansion of higher education in the 1960s had considerably enlarged the numbers of academic staff in universities. But in many institutions which gave them tenure, they couldn't be made redundant, even if the subjects they taught were no longer offered by their employers. There was a call for a means of clearing the decks to make space for a generation of new, younger academic staff. Oxford people aware of the not quite finished battle about the employer-justified retirement age will notice that. It was predicted that academics who said unpopular things might find themselves being made redundant, and again debate in Parliament became heated. The result was the Education Reform Act 1988, Section 202, which again you can easily look up, which protects the freedom of, quote, academic staff, quote, unquote, to, quote, question and test received wisdom and to put forward new ideas and controversial or unpopular opinions without placing themselves in jeopardy of losing their jobs or privileges they may have in their employment. Now that survives in the public interest governance condition of the Higher Education and Research Act of 2017, which means it's still the law, again with the original application amended slightly to redefine the institutions affected. Now this is the point where I should explain that, for those from outside the UK, that these two protections were created before the devolution of higher education to the governments of Northern Ireland, Scotland and Wales in 1998-9. So this recent legislation on higher education preserving these two provisions applies only to England, and the situation in England therefore has to be the focus of the rest of this paper. However, the Section 43 requirement, the campus freedom of speech, is still broadly recognised as binding on universities in the devolved administrations. For example, the Good Practice Guide for Scottish higher education institutions under the Counter-Terrorism and Security Act of 2015 gives Section 43 32 mentions and discusses it in some detail. And the statutes of all the UK universities which existed in 1988 still have to include, in the same words as the Act, the protection of academic freedom found in the 1988 Act, Section 202. You can always find them. Some of the protections have been reduced to the level of ordinances or regulations, but the bit that relates to the protection of academic freedom is still at statute level in all those universities. Well, the question is, does it still work? Now, the campus freedom of speech protection. Those of you from the States will know far better than me about the battle in the 90s there over campus speech codes, how Cass Sunstein argued ultimately unsuccessfully that universities were a protected space in which it might be acceptable to impose a speech code. And in 1995, the US Supreme Court upheld the First Amendment right to freedom of speech and struck down the Stanford University speech code. As I say, you'll have far more examples than I've got time for here. Now, that was taking place in the States in the period which is connected in time and also in momentary fierceness with the debates in England in the 1980s. In England in the 1980s, they were also tangled up with public concern about the alleged political indoctrination of school children. And the 1986 Act originally had 2 extra clauses dealing with that, trying to prevent that happening. But it was recognised that the situation in higher education was different. There, the protection of the minds of children should give way to a higher requirement of fearlessness in the discussion of all lawful opinion. So again, the House of Lords. The House of Lords is always a better place to look for a really good debate in England. The Commons, well, we can hardly speak about Commons debates just at the moment, but the House of Commons sets a lower standard, shall we say, for addressing itself to concerns of lasting importance. Anyway, in the debates on the 86 Act, Baroness Cox made an impassioned speech about this special need for freedom of speech on university campuses. She was so impassioned that Lord Hatch of Lusby, a bit later on in that debate, reminded her that it is, of course, possible for everyone to read what she said verbatim the next morning in Hansard. So she might consider, when reading Hansard tomorrow, whether certain of the implications of her speech did not come very close to the doctrine that when people believe something that you yourself do not believe, then they should be censured and their freedom to speak should be removed. Again, very up to date. Lord Butterworth, who'd been Vice-Chancellor of Warwick till 1985, quite close to the date of 1986 debate, pointed out that as, quote, freedom's foundations devoted to teaching, research and learning, universities know that their pursuit of truth is dependent upon free speech and lawful assembly flourishing. But he was only too well aware that the law defining the right of free speech and the law governing meetings and demonstrations abound with uncertainties, and, of course, they still do. There was little confidence that the government could be trusted to tackle it. Those who were following a year or two ago the passing of the 2017 Act, under which we're now governed in higher education in England, got used to letters from the Secretary of State that ruffled a lot of feathers. Happened then. In 1986, Lord Harris had been reading a recent letter from the Secretary of State on, quote, the treatment of politically controversial issues. In his view, it did not address the serious situation existing in colleges, polytechnics and some universities today. Politicians don't understand us, which is still true. These were the sentiments and concerns which resulted in that Section 43 of the 1986 Act, and they're clearly urgent today, though in this climate of changed and changing assumptions. The providers have revised their codes because that's what the law says they have to do. I hunted through some of them a few years ago and found that a number of them hadn't done it for maybe a decade, maybe 2 decades, but a lot of them have now. And Oxford now requires the code, its current version of the code, to be drawn to the attention of students annually. Doesn't seem to have stopped them saying you can't come and speak here, but it does seem to have been drawn to their attention. Now, academic freedom for academics. It's not simply freedom of speech. Clearly it is something more. But what? Members of the House of Lords, again, made various attempts at definition in debate in 1988. And so many members of the Lords have come from either academic careers and or the running of institutions. They do tend to be knowledgeable on the subject. Lord Swan, who'd been a cell biologist, was one. He said, by the phrase academic freedom, Academics mean independent inquiry and the pursuit of truth, wherever that may lead and in whatever area of knowledge. That is far from easy because, by definition, new ideas and new knowledge upset the established order of things. In consequence, they're often unpopular, on occasions even to other academics. From Socrates through Galileo to Darwin and on to more abstruse modern concepts, in every area of learning, history is littered with examples of new discoveries and ideas being resisted somewhat passionately. Yet it is, he said, those very advances that have ultimately affected our lives so profoundly, and nearly always for the better. Lord Morton of Schooner had another definition. Quote, academic freedom in research and scholarship is crucial to freedom as we understand it. I suggest it is also crucial to the development of new ideas. The Bishop of Rochester, for those who are not from this country, there's a dozen bishops in every House of Lords. The Bishop of Rochester listed 3 academic freedoms, including wording which found a place in the Section 202 draft. He said, quote, to research in subject of as yet unrecognised importance, the freedom to question received wisdom, and the freedom to be protected from direct and narrow political interference from the government of the day. This is what Sir March Richmond, the chairman of the Committee of Vice-Chancellors of Principals, had said they mean by academic freedom. It is not, he says, a licence to brood comfortably in ivory towers. What was then the Committee of Vice-Chancellors and Principals has now become Universities UK, which is a club of Vice-Chancellors and Principals. It has no statutory position. It's just the heads of institutions who on behalf of whom many things are said, but I'm not sure they're always asked. Lord Kirkwood stressed the dangers of not putting a proper protection into law. Again, quote, without academic freedom, universities and polytechnics simply cannot perform their duty of questioning received opinion with impunity. And though lip service may be paid to academic freedom, and it may even be enshrined in statutes, the greatest impediment to the exercise of academic freedom is the threat, if not the actuality, of dismissal. Now that's where the weak point in this protective clause turns out to lie. He thought, quote, the more insidious threat is from redundancy engineered on the grounds that the contraction of a particular discipline is required on grounds of financial exigency. In both cases, it will be difficult for the dismissed academic to prove victimization for his opinions because those are not the overt grounds for dismissal. That danger was addressed and answered in what were intended to be practical terms during the framing of the legislation. Lord Mackay of Clashfern, who later became Cambridge's commissary, its kind of in-house judicial review system until 2016, was very frank in debate in the House of Lords about the fears being expressed about what would happen once it was possible to make academics redundant. Quote, academics are afraid of malign university management and are being persecuted by their colleagues on account of their views. The first being a worse threat than the second. We've all learnt to cope with book reviews, or I suppose in the case of scientists, article reviews. But malign university management's another ballgame. He suggested that the best way to protect academic staff from, quote, potentially hostile management, and that is, he said, is what we're dealing with at this stage, is to ensure access to due processes which will protect them from arbitrary dismissal. And he spelt out what was needed, namely, quote, processes which are designed to prevent the dismissal taking effect, including, quote, an appeals machinery to ensure that all academic staff have a means of testing the grounds for dismissal and an effective measure of protection against any victimization by their colleagues on account of their views, because, of course, your colleagues may include your head of department who has powers over you. The arrangement arrived at was embodied, as I've said, in section, in fact, 2002-8 of the Education Reform Act of 1988, and the commissioners were appointed to design a model statute. The then Vice-Chancellor of Cambridge, David Williams, was one of them, and I remember him saying he'd never had such an awful job to do in his life. he was a public lawyer and had what a lot of us would regard as sensible views. It survives in the statutes, as I've already said, of all the universities that then existed. It doesn't occur in the statutes, in the governing documents of the universities which were created from the former polytechnics in the UK in 1992. They don't have those protections unless they choose to adopt them. Now, this problem of how you protect people who've been questioning and testing received wisdom and made themselves unpopular. One of the clauses got into the Act, which has had a more enormous effect than I think was then anticipated, was that it includes, quote, and this is part of the legislation, persons whose terms of appointment or contracts of employment are, in the opinion of the commissioners, so similar to those of academic staff as to justify their being treated as academic staff for the purposes of the section. Now, that's led everywhere in these universities to the inclusion under these procedural protections of senior management as well as truly academic related staff such as librarians. We see the effects in Oxford. There was a debate in the Sheldonian on Tuesday where a proportion of the audience present and voting appeared to have come from the university's management headquarters in Wellington Square. And I know this happened in Cambridge too, that the senior management who have in the in Cambridge Regent House membership, here congregation membership, would be instructed by their line managers to turn up. In the case of Cambridge, it's a postal vote, but to vote as instructed. Now that does make untidy the decision making by an academic community. It cannot do anything else. But because, of course, all the people who could claim that category were urgent to do so because it made them so hard to sack, that's the way it went. The rules created under the model statute do make it very difficult to sack academics, just because it takes so long. There's a famous story in Cambridge of, perhaps I better not give the name of the committee because it had the name of the academic in it, but an academic who was a university teaching officer flatly refused to give any more lectures until there was some apology for the way they treated his father. And a committee was formed known as the X Committee, and it met, and it said, let us resolve not to meet again until he has retired. Because there was really no way they could set about getting rid of him. It was just such a lot of hassle. Now, Oxford addressed this problem, not that problem, but the problem of the sheer time and energy. And we're talking years. I've done a lot of casework in an informal capacity over 20 years now, helping people in disputes in universities. I've seen an awful lot of paperwork, and also how long it can take. 5 years is nothing. 10 years is not unheard of. It's a long and painful and, for the university, a very, very expensive process before it gets anywhere near the courts. Now, Oxford, trying to reconstruct its own model statute, which is Statute 12, went through a very lengthy and careful process to try to create a body of staff protected by the statute whose disputes did not involve academic freedom. And if they didn't involve academic freedom, they would not have to go through all that complex process. There would be a speedier and simpler process for their removal. There have been some cases, obviously no names, no pact drill. But the necessity then arose to provide a university definition of academic freedom within the statute, in order that when people said, oh, but in my case it does involve academic freedom, I'd like the proper process, please, that could be tested against some sort of definition. The last clause of that, you can look it all up, it's in Statute 12, but the last clause of that seems to me to be the most important with reference to all the things I've just been sketching. It says, all members of the university must observe university policy concerning behaviour at work and the conduct of their duties. We're back to harassment and all that stuff again. So if that's part of the definition of academic freedom, that you're only able to claim it if you've done all those things, it does weaken it a bit pretty substantially. The rest of it's fine, well, fairly fine, but read it for yourself. It's in Statute 12. Now, I mustn't go on too long, so I will leave out my last little...
minutes or so.
How many minutes?
We'd like to have, well, it's 5 of 12.
Oh,
so
no,
we'd like to
5
have
minutes,
15
then I will
minutes.
gallop to my last little section, which I
Right.
think is of general interest, certainly
Turn
in
into a
England.
pumpkin at 12.
Yes, well, yes, just get the horses ready to carry the pumpkin away. No, I have to turn into a coach. No, it's the other way around, isn't it? It's a pumpkin, right, okay. Before I turn into a pumpkin. The question which is arising very actively now in England is the nature of an academic community. Because we've been discussing individual academics who want to say awkward things, but we are in various ways arguably a community. Now, in England, both university and degree are protected terms in law. I can't just start a college and call it a university. I can't just offer qualifications called degrees. The criteria for the award of the title of university to a new provider, as they're now called, and for, before that, the required grant of degree awarding powers, those criteria were established in 1999, revised in 2004, when for England and Wales you can now be a university if you only offer taught degrees and do no research at all. That's the period of time within this which this expression I'm about to give you has been in force. What happened was that the Quality Assurance Agency had a committee to satisfy itself that the provider complied with the requirements. It then made recommendations to the Privy Council, which then granted degree awarding powers on criteria, which were, quote, designed to establish that the applicant organisation has a well-found, cohesive and self-critical academic community that demonstrates firm guardianship of its standards. In other words, what you've got to have to be a university or grant degrees is real academics and a group of them who form a sufficient community to be able to maintain their standards and make certain that the stuff in their syllabuses is appropriate for a degree in whatever it happens to be. Now that's now evolved into the guidance in the Office for Students in its regulatory framework. And have a look at Annex C, it's all online, because that has now taken over the power to do this, which formerly lay with the Privy Council. Now it says, this new regulatory framework, that an applicant provider which wants to be put on the new register it's creating, which has no track record, which is just a starter, a beginner, must demonstrate that it has an emerging, self-critical, cohesive academic community with a clear commitment to the assurance of standards supported by effective, in prospect, quality systems. Bit of a risk, I think, but that's what it says. One with a track record, which includes Oxford and Cambridge, with their 800 years, or more in the case of Oxford, of experience, must show that it has, quote, a self-critical, cohesive academic community with a proven commitment to the assurance of standards supported by effective quality systems. Now, that's should be worrying for Oxford because it's on the list of OFS's we want you to explain yourself. Its registration as a university is currently a little precarious because it hasn't done enough to show that its attempts to widen access have been effective. We wait to see what happens if they try to remove Oxford from the list. But let's not worry too much about that now. Now, the final point I want to make here is that when all that was framed, that wording was framed, universities in this country had a self-critical community of people who tended to have worked there for some time, who knew each other, who'd have a good old argument on some committee about reforming the syllabus, but were competent to do that. Now, one of the effects of the taught-only degrees has been to create a body of academics who, although they're encouraged to have done a research degree, won't necessarily have done so. A body of academics, including people who may have risen very high and gone very far in a profession such as nursing, who teach nursing, but with no necessary research experience. So all this questioning and testing received wisdom is a bit secondary to what they actually do. even in the case of research active universities, and there's been several cases, some of which have come my way in the last year or two, of attempts to shrink your research academics, their number, by more or less forcing them to take teaching-only contracts instead. And when they say plaintively that they're rather keen on their research, they're told that that's fine. They can now do pedagogical research, undefined. Now, it means that there's a fragmentation of the old assumption that you've got an academic community which could not only maintain standards and was a requirement to be a university, but could be quite tough if it wanted to, when its freedoms to be what it was designed by the 1988 Act to be, were so seriously challenged. So I suppose what I'm saying is we've got all these rules, but all of us know that you have good procedures. The problem is then to implement them. They're not being followed, and they're certainly not being thought through in the face of the sort of problems arising which were raised in the 3 papers before mine. I think that's probably nearly pumpkin moment, isn't it?
Yes.
Right.